Name is Thanusha Sree, anak perempuan Bosraj, matrix number A211449. I'll be presenting the first case, which is the case of Polanco vs Lombardi 2020. So in this case, issues that were addressed were such as liability, negligence and assault. The plaintiff Polanco filed a lawsuit against the defendants, including Lombardi, after he was injured in an incident at a correctional facility. Polanco, who was an inmate, was assaulted by another inmate during his time at the facility. In this case, Lombardi was a correctional officer at the facility where the assault took place. The plaintiff alleged that Lombardi, along with other defendants, was negligent in providing proper supervision and failed to prevent the assault, which led to Polanco's injuries. Polanco's claims included that the defendant had a duty to protect him from harm and that their failure to act appropriately led directly to the assault. Legal issues of this case is that was there a legal obligation for correctional officers to ensure the safety of inmates, and did the failure to provide proper supervision or take preventive action constitute negligence, and did the action or lack of action by the defendants directly lead to the harm that Polanco suffered, or were there intervening causes that absolved the defendants of liability. For the court judgment, the trial court had originally dismissed the case because Polanco had not provided sufficient evidence to support his claims that caused assault to Polanco. The court concluded that there were genuine issues of material facts that needed to be resolved by a jury rather than dismissed outright. The court was also not clear whether the defendants were negligent in their duty to protect Polanco and whether their actions or lack of actions contributed to the harm he suffered. The Supreme Court emphasized that this case required a trial to resolve. Since the case involved unresolved factual issues, the court remanded the case to the lower court for further proceedings, allowing the case to go to trial. Thus, the judgment favored Polanco, allowing his claims that caused assaults to Polanco to move forward. In my opinion, this case involves a claim against correctional officers after the plaintiff Polanco was assaulted by another inmate. The main issue was whether the officers were negligent in failing to prevent the assault, which they could have potentially prevented through better supervision. The Rhode Island Supreme Court ruled that there were enough factual disputes about the officers' actions to send the case to trial instead of dismissing it outright with summary judgment. This case highlights the importance of holding correctional officers accountable for ensuring immune safety from any kind of assault and ensuring that public institutions are not immune from responsibility for negligence.
Next, GMP Casa Security Sdn Bhd versus Muhammad Amirul Amin. The facts of the case is the appellant GMP Casa Security is a private agency that provides service of personal bodyguard. Jaafar was assigned to protect Dato' Ong Teck Kwang. As part of his role, he was equipped with a firearm by GMP. While performing his duty, Jaafar suddenly shot and killed Dato' Ong Teck Kwang. Then he unlawfully discharged the firearm towards the public, resulting in the injuries of Amirul. The incident occurred while he was on duty as a bodyguard, and the firearm he used was issued to him by GMP for the purpose of providing security. Amirul filed a suit against GMP, claiming damages for the injuries caused by Jaafar's action. Both of the High Court and the Court of Appeal held GMP Casa Security liable for Jaafar's action. Then, GMP appealed to the Federal Court that Jaafar's action were a personal deviation. The first one is whether the employer GMP is vicariously liable for the wrongful acts by its employee Jaafar, who unlawfully discharged his firearm and caused injuries towards Amirul while performing his duties as a personal bodyguard. Second, whether the principle of vicarious liability applies to torts or criminal acts committed by employees in the course of their employment. Third, whether Jaafar's wrongful act of shooting Amirul sufficiently connected to his job role to justify holding GMP liable under the principle of vicarious liability. The last one is whether GMP Casa Security, the employer, created risk by providing a firearm for the employee. The court dismissed GMP's appeal and upheld the decisions of the Court of Appeal and the High Court, holding that GMP vicariously liable for Jaafar's wrongful act. Lastly, in my opinion, the Federal Court's ruling in GMP Casa Security is a just application of vicarious liability. It emphasizes accountability for high-risk businesses. Through the implementation of the close connection test, the court was able to strike a fair balance between encouraging responsible risk management by employers and protecting innocent victims like Amirul. Although the case emphasized challenges in establishing liability boundaries, it upholds the idea that companies that take on significant risks are accountable when those risks come to us.
My name is Aisyah binti Norhamidi A212163, and I will be representing the third case, Wallace D. Lewis against State of Maryland. The facts of the case is the appellant, Wallace D. Lewis, stabbed the victim, seriously injuring him, and he was charged with first-degree assault. The evidence of the crime, including a video from a camera that is near the location of the stabbing, and also a slow motion of the portion of the video. The legal issues for the case is whether the jury instruction in allowing conviction is appropriate for assault. The court's judgment is that the appellant was charged with the battery form of assault elevated to first-degree assault by the intent to cause serious physical injury. The crime requires a proof of specific intent, and it shows from the video that the appellant wanted to cause serious injury to the victim. In my personal opinion, in the case of convicting assault, it involves intentional infliction of seriously bodily harm. The fact that the appellant slapped the victim suggests a deliberate act of violence, which aligns with the severity of the charge. The nature of the injury inflicted is critical. If it resulted in substantial harm, this would further affirm the appropriateness of the classification. Also, the appellant's intent at the time of the incident is crucial. Evidence show that the stabbing was premeditated, as the appellant had said, "Baby, get the knife," to his wife, is an indication of ill intent to the victim, as it also strengthens the case for first-degree assault. With those requirements being fulfilled, the conviction of assault for Wallasey Lewis, the appellant, is appropriate.
My name is Nurul Asyikin,
A212160.
Today I will present the case. The name of the case is Wright versus Chief Constable of Greater Manchester Police 2022. In this case, Wright, who was the claimant, sued the Greater Manchester Police for batteries and false imprisonment. Wright, who stopped by the police officers in relation to suspected crime. The officers attempt to arrest him, and during the arrest, Wright claimed that the police officer used excessive force to restrain him. And after being detained, Wright argued that the reason for his detention had not been explained in the details, and he was not informed on what legal ground for his detention. So he brought the claim against the police officer for battery based on the excessive force that has been used on him, and false imprisonment, arguing that the police has no lawful right to detain him. The legal issues that arise here are whether the detention of Wright was lawful or it amounted to false imprisonment, as the police officer cannot provide the logical explanation for the arrest. And the second one is whether the police officer used excessive force during the arrest can be liable as battery or not. The judgment of the case, the court found in favour of Wright, concluding that the police officer had acted unlawfully in two aspects, which were battery and false imprisonment. The court held that the force used by the police officers during the arrest was excessive and amounted to battery. The force that has been used to restrain Wright was not unreasonable. The court also found that the Wright detention was clearly unlawful. The officers had failed to provide a clear legal issue for his detention or explain on what legal ground for his arrest at that time. As a result, the detention amounted to false imprisonment because Wright had been deprived of his freedom without legal justification. From my point of view, clearly that police officers were liable for battery and false imprisonment, as they cannot give an exact reason why they try to restrain Wright. The police officer must use only a reasonable force in carrying out their duty, including arrest. Any form of force that is more than necessary to achieve the lawful purpose of the arrest or detention will be deemed excessive and unlawful. For false imprisonment, the person cannot be detained without a clear legal basis, and failure to inform the individual of the reason for their detention can lead to a claim. The right of the person who has been detained to know in what ground for his or her detention is fundamental.
I'm Kabhiniesyaa Ragunathan, metric number A219504. Today, I'm going to present the case Iqmal Hisham bin Harun against Siti Norhamidi binti and others, 2023, 9 MLJ 865. In this case, the first defendant, who was a police inspector and narcotics investigation officer, arrested the plaintiff as he possessed drugs. The next day, an application for remand on the plaintiff was made in the magistrate court and approved the remand for 6 days. Later, it was continued for another 6 days. The plaintiff was charged in the court and was held in prison. Hao Mei, who is a deputy public prosecutor, had made a police report which revealed that the minutes in the investigation papers had been forged. The plaintiff later pleaded guilty and was sentenced to prison. Upon his release, the plaintiff brought an action against the defendants for abuse of power and false imprisonment for a period of 106 days, starting from 21 November 2016 to 7 March 2017. Based on the plaintiff and conducting the wrongful act, the first defendant was under the second and third defendants' control, and employer was the fourth defendant. Therefore, it was argued that defendants 2 to 4 are liable vicariously towards the action. The legal issue here is whether the detention of plaintiff lawful or amounted to false imprisonment, as the police officer forged the minutes. Secondly, whether the second, third, and fourth defendants are vicariously liable for the first defendant's wrongful act, which was done by frolic of her own. In this case, the court held that the first defendant's wrongful act of forging the minutes in the investigation paper amounted to false imprisonment of the plaintiff for a duration of 106 days. The act was closely related to the course of employment and act closely related to the first defendant's duties and obligation as an investigating officer and police officer. Therefore, according to Section 5 of Government Proceedings Act 1956, the second, third, and fourth defendants, who is the employer and principal of the first defendant, shall be vicariously liable for the actions of the first defendant. Therefore, the court allowed the plaintiff's claim against defendant 2 to 4. In my opinion, the position of Iqmal Hisham bin Harun against Siti Norhamidi binti and others is valid, as the act of police officer forging the minutes in an investigation paper clearly constitute to false imprisonment, and the court has upheld the Section 5 of Government Proceedings Act 1956 that promotes the liability of government in tort room. The close connection test, which was used in deciding the case, does promote justice by considering whether it is fair and just to hold the employer responsible for the employee's action based on the closeness of the connection between the torts and the employment. This way, employers will be more concerned and involved in proper hiring and selecting the right employees. Thank you.